different ways your US citizen child can help you work and stay in the US. Stay and work in the US. In this video, I'll talk about 6 ways. Bijou Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Let's get right into it. Number 1, stay of removal. Stay of removal. Who can grant that? The BIA, the Board of Immigration Appeals, the DHS, Department of Homeland Security, and the federal court. This one happens, I'm gonna give you a scenario, right? You went to court, you have used up all your immigration reliefs, all type of reliefs, and you find yourself with an order of removal, order to be removed from the United States, right? If you go to the BIA, you can appeal it, right? Timely appeal it. But if you didn't know about it, you couldn't go in federal court, because remember, if you go to the BIA or federal court, you have to do it timely. But let's just assume you didn't do it timely, and then you have the only option is to do it through DHS, Department of Homeland and Security. There's an application that you have to fill out. So when you fill out this application and the stay of removal is granted, it simply means that you become under order of supervision. So you have to follow all the instructions coming from ICE at this point moving forward. The reason you're doing it is because you have an order to be removed. You have a child, a US citizen child, who's not 21 yet to actually apply for you, but you have to work, right? You don't want to go because you can't really just leave and leave your child here. But you can't just stay here without working either. So that's when you go with a stay of removal. This is really a last type of resort, relief, type of relief. My friend, if you want to apply for it, please call my office, 202-751-2180, because you're going to need a lawyer for it to get approved, and you're going to need the lawyer to help you with this order of supervision, because you don't want to mess it up and find yourself again before detained. Really, at this point, if you mess it up, you get detained and removed, right? You don't want that to happen to you. Number 2, humanitarian parole. I've talked about humanitarian parole before, but I've talked about it differently. And in this video, we're going to be so specific as to how a US citizen child can help you apply for humanitarian parole. So humanitarian parole is a form of relief. Remember, parole simply means in short terms, right? Permission either to leave the US if you cannot leave without permission, of course, and then either permission to actually come in the US or permission to stay in the US and work for a very temporary period of time. Usually it's 2 years, and it can be renewed as well. So the way this one is going to work is if you have a US citizen child who needs medical care. So you're going to have to prove medical records and stuff like that in order for this to be approved, and then show a significant public benefit, and then humanitarian reasons, which is the child that is sick and need care. So, and this is a very discretionary measure as well, case by case basis, but it's something that you can look into, right? Number 3, withholding of removal. When does withholding of removal come into play? Withholding of removal come into play when you go to court and you file for asylum, and the asylum doesn't get granted, and then the alternative, usually most lawyers will list all form of reliefs in your asylum, defensive asylum application when you go to court, right? So among other things, withholding of removal is something that can be granted. This is a mandatory relief. Okay, it's like if you meet the standard of it, then the judge has no option but to grant you withholding of removal. And it helps a lot if you have a U.S. citizen child to make it into the argument and how it's going to cause extreme hardship on them if you were to be removed. And this one too will help you get a work permit, because the goal is for you to, remember, stay and work in the U.S., right, while you're raising your children. So, and this one too is going to give you a work permit, renewable of course, but still something to have so you can work. Number 4, defer action for medical reasons. So this one is not on the child. Now the sickness is not on the child, the sickness is on you, but still you have a U.S. citizen child to help you make your case, right? It must be a serious medical condition that you have, long-term presence in the United States, and close family ties. That's when we use the child to help you out with this petition. And once you get it, you get a work permit, you can apply. Once you get approved, you can apply for a work permit as well. Renewable again, but still something to maintain you in the U.S. and work while you are raising your child until the child turns 21. Then they can petition for you, right? So number 5, cancellation of removal. This one is it has a very high standard to prove in court. You really need a lawyer for this one. Cancellation of removal, first of all, you have to qualify for it. I've talked about it a lot on my channel. Cancellation of removal really applies when you have been in the U.S. 10 years prior to you receiving a notice to appear, 10 years before receiving a notice to appear, and then you have a child born here. You can't just leave. You want cancellation of removal to be granted to you, provided that you can show extreme hardship on the child. So this one too, it's good because this one can lead to a green card. The only one that can lead to a green card among those other 4 is cancellation of removal. Then we have the last one that everybody knows, I-130 petition, when the child is actually over 21 and working. Of course, if it's not working, then we can find another sponsor to pretty much file the form I-864 for you. But this one, if you have a U.S. citizen child past the age of 21, they can apply for you as well, provided that you meet all the admissibility criteria as well. So those are the 6 ways that a U.S. citizen child can help you stay and work. Remember 2 words, stay and work, because that's the reason you want a valid work permit so you can work, okay? So if you need really help, we're here to help. Again, we're here to help. Please call me 202-751-2180. Consultation fees apply. Email bijou.ngwandaesq@gmail.com. Until next time, bye-bye.